Hello, and welcome to Fasken's 13th consecutive mining series. My name is Virginia Schweitzer, and I'm a member of the Fasken Global Mining Group, as well as a partner and the co-managing partner of Fasken's Ottawa office. Today's session is the third of 9 sessions, which will continue until Tuesday, March 7th. Before we begin, please refer to the slide on your screen for some housekeeping items. Now I will turn it over to my colleague, Kai Alderson, the moderator for today's presentation, Climate Litigation and Greenwashing Risks in the Mining Sector. Kai, over to you.
Thank you, Virginia. And I would like to say hello and thank you to everyone on this webinar for joining us today. My name is Kai Alderson. I am an energy and natural resources lawyer in Fasken's Vancouver office. With a practice that is increasingly focused on climate-related matters. So I'm really looking forward to this presentation today. And it's my pleasure to share the virtual stage with my colleagues to present the session, Climate Litigation and Greenwashing Risks in the Mining Sector. This session will provide an overview of emerging risks for mining companies arising from climate-related litigation and allegations of greenwashing. And we're not going to stop there. In addition to highlighting these emerging risks, we will also talk about some practical things that can be done to assess, evaluate, calibrate, and then mitigate those risks. I honestly can't think of a better panel to walk us through these issues, so let me get right on to introducing them to you. First, we have my colleague, Kimberly Potter. Kim is a partner in the Litigation and Dispute Resolution Department in Fasken's Toronto office. Her practice focuses on commercial disputes and administrative law with industry expertise in mining. Kim acts for companies in a wide range of industries in matters involving allegations of breach of contract, negligence, shareholder disputes, claims against directors and officers, and disputes over business valuation. She holds a certificate in mining law from Osgoode Hall and is the head of our firm-wide Climate Action Committee. Next up, we will have Gordon Raman, partner in Fasken's Toronto office. Gordon's practice focuses on mergers and acquisitions, corporate governance, and capital markets. As part of his corporate governance portfolio, Gordon is chair of Fasken's ESG and sustainability practice, which brings together lawyers from a broad range of practices to provide comprehensive advice to clients on ESG-related matters. Last but not least, I'd like to introduce Antonio Di Domenico, partner and co-leader of Fasken's Competition, Marketing, and Foreign Investment Group. As former counsel to Canada's Commissioner of Competition, and having served as counsel in many of Canada's most significant competition matters, Tony is widely recognized as one of Canada's leading practitioners in competition law and litigation, which is, as we will see, a real point of focus where much of the activity around alleged greenwashing is happening these days. So really lucky to have Tony weighing in. Before I hand it over to Kim to kick things off, I wanted to let you know a bit about the shape of the presentation. So each presenter will give an initial presentation, followed by a bit of a panel discussion where we will address some of the cross-cutting questions in this emerging area of law. And then we'll end with a question and answer segment. And we really do welcome your questions. So please ask your questions as we go via the Q&A box located at the top right of your screen. We will do our best to answer as many of them as we can. With that, Kim, we'll turn to you. Please take it away.
Thanks, Kai, and thanks everyone for joining us today. As Kai mentioned, I'm going to be speaking about climate litigation generally. You can sort of think of my part of the presentation as the litigation without the misreps. And you'll hear more from Gord and Tony on the securities and competition law and greenwashing aspects of climate litigation. Next slide, please. So we should define our terms, being lawyers. What is climate litigation? So there's no sort of agreed upon set definition, but the Sabine Center for Climate Change Law at Columbia Law School, as well as the UN Environment Program, use these sort of following general criteria for deciding what is and what isn't climate litigation. First, there has to be some kind of case or proceeding before an adjudicative body. It can be an administrative body, a court, but that's sort of one of the criteria. The second is that the case raises material issues of law or fact relating to climate change mitigation, adaptation, or the science of climate change. So that's really what we're talking about when we're speaking of climate litigation. And as we all know, litigation is being used to compel not only governments, but also corporate actors to take more ambitious climate change mitigation and adaptation goals. Next slide, please. So this is a map. It's current as of May 2022, so you can sort of see where we're seeing a lot of activity in this space. And we know that climate litigation is becoming much more common worldwide. The number of climate change related litigation cases has more than doubled since 2015. So we're seeing an increased rate of these kinds of cases. And we expect that rate to increase. And while currently you can see from this map, a lot of the activity is centered around sort of high income countries, we're expecting that there's going to be much more activity in the global south as well as these cases become more popular and we have more precedents. So given that increased rate of these kinds of cases, it's important to be aware of what conduct can generally expose a corporation or its directors and officers to liability, and also what enforcement mechanisms are in place. And so that's what the balance of our presentation is geared towards. Next slide, please. So one sort of category of types of claims that we're seeing are claims against directors and officers. We know that directors and officers must consider the risks that climate change presents for the corporations they serve. And directors and officers have two duties set out in legislation, at least in Canada. They have a fiduciary duty, which means that the directors and officers are required to act with a view to the best interests of the corporation. And they also have a duty of care, which means that in managing or overseeing the management of risks, directors and officers must meet the objective standard of what a reasonably prudent person would do in comparable circumstances. And so an area for potential litigation is imbuing these obligations with obligations to take into consideration the risks that climate change and other climate-related risks pose to the future of the business. Later on in the presentation, we'll give some more practical tips, but just because we're talking about what these duties are right now, as a very general matter, to comply with these obligations, it's important that boards get reports and recommendations from management and external sources as necessary so that they're satisfied that the corporation is addressing climate change risk appropriately. And those duties, of course, are not set in stone. And as norms change and as knowledge about climate risks change over time, the content of those duties will change in kind. So there are different types of claims that shareholders and others can bring against directors and officers of a company. So shareholders can file personal claims or derivative actions against a company's directors for their failure to appropriately manage climate-related risks. And directors may also be vulnerable to oppression claims that may be brought by shareholders as well as other kinds of complainants if they argue that the directors unfairly disregarded or unfairly prejudiced their interests in violation of their reasonable expectations. Many of you will probably have heard the recent news that there has been a claim brought against the Shell PLC board of directors by an NGO called Client Earth. They had said about a year ago, I think it was March of 2022, that they intended to bring this action, but it's now been issued. So this is a derivative action brought by Client Earth, which is also a shareholder of Shell PLC, against Shell's 13 executive and non-executive directors. And the claim is that the board is personally liable for the company's failure to manage its climate risks, meaning that it's failed to implement a climate strategy that Client Earth says truly aligns with the requirements under the Paris Agreement. And that includes a failure to produce operating plans and budgets that reflect the company's target to become net zero emissions energy business by 2050. So those are sort of the basis upon which that claim was made. And it's not just Client Earth that's involved. This claim has gotten significant support from Shell's institutional investors, including large pension funds and asset managers. And this is really the first case where a company's board has been challenged on its failure to properly prepare for the energy transition. So needless to say, lots of people are watching this case with great interest to see what happens, and it may well spur copycat type litigation elsewhere. Next slide, please. The next category of litigation I'm going to speak about are challenges to permitting. These are cases where there's a challenge to either environmental permitting or review processes that plaintiffs allege overlook the project's climate change implications. So these are challenges to government action. They don't challenge corporate action directly necessarily, but obviously can have impacts on projects that require regulatory permits, both if there's a judicial challenge, but also because these are the kinds of things that decision makers are concerned may be levied against them if they don't take those climate change considerations appropriately into account. There have been a number of these kinds of cases in Canada, so I just have 3 for illustrative purposes here, and then at the bottom 2 are cases in other jurisdictions, so I'll speak to each of them briefly. The first case is Ecology Action and the Ministry of Environment and Climate Change. And this is a case where the applicants brought an application for judicial review, meaning they're asking the court to review a decision made by a government actor, alleging that the Canadian government improperly assessed the climate consequences of exploratory drilling off the coast of Newfoundland and Labrador. And in that case, the court ultimately dismissed the application on the basis that the assessment that they were saying didn't properly take into account these considerations was non-justiciable, meaning that it's not the subject of court review. So a lot of the cases that have been brought in Canada so far, where there's been a challenge to government action, have been kicked out at a preliminary stage on the basis that this really wasn't a matter for the courts. We're talking about discretionary decisions made by government bodies. It's not reviewable by the courts, and it's not justiciable. The second case on the list is the World Wildlife Fund Canada and the Ministry of Natural Resources. This is a 2022 case that's still pending. In this case, the 2 NGOs filed an application in the Federal Court of Appeal for a judicial review of the federal government's decision to extend 20 oil and gas permits held by 2 corporations dealing with offshore oil and gas exploration in BC. So a similar kind of case, a similar kind of fact pattern as the first, similar kinds of allegations about the failure to appropriately take into account the climate impacts. And as I said, that one's still pending, so we're waiting for a decision on that. The third case is the Highlands District Community Association in British Columbia. This was an appeal of an application for judicial review that was dismissed. In that case, a mine inspector issued a permit for the operation of a rock quarry, and the applicants said that that decision to issue the permit was unreasonable because the inspector failed to consider the climate change impacts of the quarry under the Mines Act. And that case was dismissed on appeal, so upheld the earlier decision, finding that the inspector had discretion and his failure to consider climate change impacts did not render the decision unreasonable. And the Supreme Court dismissed the further appeal of that decision. So this is an interesting case because it's about the exercise of discretion. And so while in that case they found that the exercise of discretion was not unreasonable because of this failure to take into account climate change impacts, what's reasonable is going to change. And so just because in that case they didn't find the decision to be unreasonable doesn't mean that it won't be in the future. And it's an interesting case because it highlights that the exercise of discretion may require, on a go-forward basis anyway, taking into account these kinds of considerations. The last two, we have Greenpeace Nordic Association and Ministry of Petroleum and Energy. This is a Norwegian case where a coalition of environmental groups brought a claim against Norway's Ministry of Petroleum and Energy. They argued that the Norwegian constitution had been violated because the ministry issued a block of oil and gas licenses for deep sea extraction. So this case is really based on the particular constitutional requirements in Norway. The lower court rejected the plaintiff's claims, finding that the government had appropriately considered the climate change impacts. That was upheld on appeal and is now going to the European Court of Human Rights. So it's going all the way up. So that's a case that will be interesting to see what they ultimately decide and how the constitutional rights that pertain in Norway contemplate these kinds of claims. Finally, on the list, we have Youth the Verdict and Warta Coal. This case got a lot of press when it came out. It's a case where there was a group of plaintiffs who are 30 years and younger, and they filed an objection to Australia's approval of a new coal mine. The plaintiffs in that case alleged that approving the mine would violate the right to life, the protection of children, and to culture, which are rights protected by Queensland's Human Rights Act. And so the way the process worked there is the court was asked to give a recommendation to the government. They didn't make a go, no-go decision. And in November of last year, the court recommended to the Minister of Resources that the project not go ahead because of its contribution to climate change, environment impacts, and because of the erosion of human rights. So this case was significant because it's the first time a Queensland court has recommended refusal of a coal mine on climate change grounds, and the first case linking human rights and climate change in Australia. And so that latter piece, I think, is particularly significant to see how, courts going forward are linking whatever constitutional human rights protections to potential climate change impacts of private projects. Next slide, please. So in terms of cases to watch in the coming year, the first is Mature in Ontario. So this is a case, one of many that I referred to earlier, where there's a direct challenge to government saying they're not adequately taking into account the impacts of climate change, and they're not adopting ambitious enough targets to meet the commitments under the Paris Agreement. What's interesting about this case is that because it was a challenge to a repeal of Ontario legislation, the 2016 Climate Change Act. Unlike the other cases that were all kicked out on the basis that they're non-justiciable, this one had a clear sort of linkage to law, right? There was a law that was repealed. And so for that reason, this case defeated a motion to strike where the others had been unsuccessful. So this case went to an actual hearing in the fall, and it will be interesting. This was the first case sort of on the merits of this nature that we're seeing in Canada. And so it'll be interesting to see what the ultimate decision is on that case. The next is this Vancouver City Council motion to fund a class action. So the previous City Council in Vancouver, under the previous mayor, passed a motion to allocate funds for a potential lawsuit against major oil companies in Canada to seek contribution to the mitigation efforts for climate change. So nothing has happened since. There has been no action, but it's interesting to see municipalities, there are other municipalities that are also making similar noises about options for the cities to try and recoup some of the costs that they're going to incur to deal with climate change impacts. So it'll be interesting to see if anything arises from this or other municipalities take similar action. The last three on the list are international cases, but will likely have broad impacts. The first case on that list is a Peruvian farmer filed claims for declaratory judgment and damages in a German court against RWE, which is Germany's largest electricity producer, on the basis that the allegations that RWE knowingly contributed to climate change by emitting substantial volumes of greenhouse gases, and therefore bore some responsibility for the melting of mountain glaciers near his town of Juarez. And so he's seeking damages. He wants RWE to reimburse him for the costs that he will incur, and others will incur to establish flood protections. It was kicked out early at the lower court on the basis that causation had not been established. So in a lot of these sort of novel tort cases, causation's a big deal because it's pretty hard to draw a direct line between a particular corporation's actions and the increase in emissions. We know that it does in a general sense, but how can you sort of say, because of the actions of this particular corporation, therefore the melting of the glaciers, therefore the flooding? So on that basis, the lower court said no, but the court reversed on appeal and overturned that preliminary dismissal. So it's now going to move into an evidentiary phase, and it'll be interesting to see how that court deals with these complicated causation type issues. Second to last on my list is the BNP Paribas claim, which is this is a new claim, but there have been a handful of claims that had been brought under the French duty of vigilance law. And that was a law enacted in 2017 in France to enhance oversight of corporate responsibility and requires large corporations to take into account environmental, human rights, and health risks into their planning. And there are other European jurisdictions that have similar type laws, such as Germany and the Netherlands. So this case was brought against BNP Paribas, which is the Eurozone's biggest bank, on the grounds that its loans to oil and gas majors breached a legally binding duty to ensure its activities do not harm the environment. So as we have governments passing more strict laws, that provides the sort of legal hook that allows people to bring claims and not shield themselves behind the idea that this is all just a matter of government discretion and policy. So it'll be interesting to see what happens with that case. I think just a couple of days ago, there was a case also based on this duty of vigilance law brought against Total Energies, which was about the human rights impacts and environmental impacts of an oil project in Uganda and Tanzania, which was dismissed on procedural grounds. But that was a widely anticipated case, looking to see how that law would be interpreted. That ultimately wasn't because of the process. Finally, there's this BNDES claim that's been brought in the Brazilian courts against Brazil's National Development Bank. And the NGO is seeking to require the development bank to develop a GHG emission reduction plan to help guide investments. So seeking a proactive decision on behalf of that bank about how its investments are going to be made going forward that takes into account climate change impacts. This is the first case of its kind against a development bank in the world, and may well have repercussions for the finance industry more generally. So it's a good case to watch. Next slide, please. I think that was my last slide. Yes. So with that, I will turn it over to Gord.
Thanks very much, Kim. Pleasure to be here. Casey, if you can go to the next slide. What I'd like to cover in my part of the presentation is the considerations around securities law in relation to climate litigation and greenwashing. And I want to cover four things. First, what's the legal framework in Canada that relates to potential litigation under securities law and greenwashing? And similarly, what's the framework in the US at a very, very high level? What I'd like to do then is just touch on what some of the proposals are for climate-related disclosure by the securities regulators, both in Canada and the US, and then mention a couple of examples of litigation where the legal frameworks that we discuss are actually used to make certain claims. Next slide, Casey. So the starting point in Canada, at least, is when it comes to securities legislation, there aren't any specific disclosure requirements around ESG or environmental issues or climate-related issues yet. So what governs the state of the law today is with public companies, as they have a requirement to disclose anything that's material to their business, particularly material risks. If there's a climate-related issue that is material to a public company, it must disclose it. And then the second part of that is whatever a company discloses can't be misleading. So it has to be correct. So that's kind of the state of the law. Nothing specifically related to climate yet, but it is coming, and we'll touch on that. Next slide, please. And when we talk about liabilities under securities law, there's two types of liabilities that you'll hear about. First is primary market liability, and the second is secondary market liability. Think of primary market liability as the liability that a company could suffer if it makes a misrepresentation in an offering document, like a prospectus, when it's issuing securities from Treasury. Secondary market liability relates to liability that a company might face just for its ongoing reporting obligations. So each year, a company has a proxy season, discloses a set of continuous disclosure documents. If there's a misrepresentation in those annual documents, the regime that covers that is the secondary market civil liability regime. And that's what we're going to mostly focus on. Next slide. And under Canadian securities laws, when we talk about liability, there's a few basic definitions that are useful to understand because these come up over and over again. The first is misrepresentation. And a misrepresentation is defined as an untrue statement of a material fact or an omission to state a material fact that is required to be stated in order to make another statement not misleading in light of the circumstances in which it was made. So essentially think of it as you have to state things that are important, but if you make an untrue statement of something that was important, that's a misrep. Or if you should have said something to make everything else that you have said not misleading, that could also be a misrepresentation. And when Tony gets to his part of the presentation, just take a look at the slightly different definitions of what are misrepresentation under securities law and competition law. The second definition that's very relevant is material fact, because it's used in the definition of misrepresentation. Essentially, this is a fact that would reasonably be expected to have a significant effect or value of the market price or value of the securities. Next slide. This comes up less so, but I'm just going to touch on it. A material change is similar to a material fact definition, but it essentially covers any change to the business operations or capital of an issuer that would be expected to have an effect on the value or market price of the securities, or a decision by a board to implement such a change. Next slide. This is a key definition, document. Under securities law, you might think that a document involves all documents that a company is required to file under securities law. So think of it as an annual information form, MD&A, press releases, and it does cover all of those things. But if you look at the very bottom of the slide, clause number 3, the definition of document is broad enough to pick up all kinds of other things, any other communication, the content of which would reasonably be expected to affect the market price or value of a security. So as an example, companies that put out sustainability reports, a sustainability report is not required under securities law, but a company that voluntarily puts out sustainability reports, that sustainability report could be deemed to be a document, and any misrepresentations in that sustainability report could attach liability to the company. Next slide. We've described the definitions, but how do they actually play out? This is the actual provision under securities law that deals with misrepresentations in a prospectus, but I'm going to go to the next slide and focus on the regime that governs misrepresentations in ongoing continuous disclosure documents or secondary market disclosure. So when you read 138.3, the thing that attaches liability is where a responsible issuer or a company releases a document that contains a misrepresentation, any person who acquires or disposes of that company's security during the period between the time when the document was released and when the misrepresentation was publicly corrected has, without regard to whether the person relied on the misrepresentation, a right of action for damages. So any issuer that puts out a document, the document has a misrepresentation in it, until the moment they correct that misrepresentation, anybody that bought or sold securities within that time could bring a right of action for damages. And this is the key provision that triggers liability under Canadian securities laws. Let's go to the next slide. Again, this is just fleshing it out a bit more in terms of other provisions that provide for liability. So I'm going to skip this slide and go to the next one. So now that we have a very basic understanding of what triggers securities law liability in Canada, let's just touch on how the system works in the US. So there's two key pieces of legislation in the US, which you'll often see heard referred to as the 1933 Act and the 1934 Act. The 1933 Act covers registration statements and prospectuses and misrepresentations in a prospectus, very similar to, when you think about it, very similar to our primary market liability regime under Canadian securities laws. And the 1934 Act provides for disclosure obligations for companies once they're listed. So again, ongoing disclosure obligations. And this is very similar to the regime that covered we just talked about, the secondary market liability regime in Canada. And the key provision here is the very last bullet, which is 10b-5. And Section 10b-5 of the 1934 Act broadly prohibits any kind of fraudulent or deceptive practices and untrue statements or omissions of material facts in connection with the purchase and sale of securities. So again, you start to see similar uses of words such as material facts. And these are broad provisions and essentially apply to any information released to the public by a company, and certainly picks up press releases, quarterly and annual reports, all the things that you are required to file under securities laws. Let's go to the next slide. I'm going to jump to the bottom of the slide first, which is misrepresentations. So misrepresentation under US securities laws is a false or misleading statement or a material omission, which renders other statements misleading. So again, very similar to the Canadian definition, same elements, with an intent to deceive. The intent to deceive is interesting. It's not found in Canadian law, but because the US securities law is based on concepts of fraud, the intent to deceive is a basic element of fraud, which is why you find it in the US definition. Then jumping to the top of the slide, through all this, you hear the word materiality used. Materiality is not defined, certainly in the U.S. legislation, and the U.S. Supreme Court has spent some time defining what they think is material. And the way they look at it, if you look at a piece of information, you're trying to decide whether that piece of information is material or not. According to the Supreme Court, you have to weigh that piece of information and how a reasonable investor would look at it, and whether it would significantly alter the total mix of information that's already out there. And if it would alter that total mix of information in a reasonable investor's mind, then the piece of information that you're considering is probably material. Let's go to the next slide. So that gives us a basic understanding of the Canadian law and the US law frameworks on how securities legislation and how liability under securities legislation can arise. What I wanted to touch on here is, well, what are the requirements around climate disclosure? In 2019, the Canadian securities authorities put out kind of a reminder on, again, what do companies need to do on climate-related issues? And essentially, it provided some guidance, but no specific mandates. And then in October 2021, the securities regulators published National Instrument 51-107 for comment. So it was a proposed national instrument. And the idea was this was going to start to provide some actual requirements on what would need to be disclosed in connection with climate-related issues. The comment period for that expired in March of 2022, and nothing has happened since then. Let's go to the next slide. And the reason nothing has happened since then is right after the comment period expired, two things happened internationally. The first was the International Sustainability Standards Board, which is a standard-setting organization for sustainability and climate-related disclosure, came out with two exposure drafts, one for sustainability-related disclosure, one for climate-related disclosure. And the Canadian securities authorities are looking at this to see what these requirements are under these international standards. And secondly, and perhaps more importantly, the SEC, actually, let's go to the next slide, Casey. The SEC came out with its version of what it wanted for climate-related disclosure. So that came out kind of spring of last year. And as soon as it came out, people started comparing the SEC version to the Canadian version. And the main difference is really that the SEC version of climate-related disclosure mandates or potentially mandates Scope 1 and Scope 2 disclosure versus the Canadian requirements. It wasn't a hard mandate that you had to disclose Scope 1 and Scope 2 emissions, but you certainly could. And if you didn't, you had to explain kind of why you didn't. The second, so this is the reason why the Canadian securities regulators have not done anything. They're monitoring what's going to happen both internationally and in the US, and then likely come up with their position on this. And the SEC, I think, just recently announced that it's probably around April when it's going to come out with its final rule around climate-related disclosure based on what changes it makes to the proposals that it had last year. The second thing that I want to mention with the SEC is in 2021, they established this ESG Enforcement Task Force. So it's an enforcement task force of the SEC. And essentially what it's doing is going out and looking at disclosure of public companies and identifying any material gaps or misstatements, particularly related to climate risks under existing rules, and then taking action with respect to those matters. So I'll come back to this in a short while. So let's go to the next slide. So that brings us to, we've understood what the legal frameworks are, understood what the potential climate-related disclosure regime might be, and let's see currently what's the state of what's happening. How is securities law being used to potentially bring litigation claims? I want to touch on just two or three examples on how this has been done. So the first is the Nessier versus Barrick matter. And in this case, and I'm just going to highlight the facts very briefly so you can get a flavor for how people frame these claims. So in this case, this had to do with an open pit mine in between Chile and Argentina that Barrick had. And under the environmental permits that Barrick had, essentially the environmental permits required that Barrick could not do any kind of pre-stripping, so stripping away the waste rock before they get to the mineral ore. They could not do any pre-stripping until Barrick had put in place a water management system at the site. And it so happens that Barrick announced at some point that it had started pre-stripping operations at the mine in compliance with all applicable requirements. As it turned out, there was an environmental issue. And so then the plaintiffs here looked at the environmental issue and said, well, how did this environmental issue happen if the water management system was in place? Went back and then looked at the disclosure of Barrick and said, well, Barrick had disclosed that pre-stripping had only started when all applicable requirements were met. So how could it be, what were these requirements with respect to the water management system met or not? And so they brought a claim in Quebec for a class action, and this is in process. But essentially, the Quebec Court of Appeal allowed the class action to proceed. So you can see how issue happens, go back, look at what the disclosure is, see if there may be a hole in the disclosure, make a claim. Let's go to the next slide. The Greenpeace Canada complaint against Kinder Morgan Canada, the Barrick one that I just described is a secondary market liability claim. So Barrick is obviously public. They look at their ongoing disclosure and see if there's an error in the disclosure, bring a claim. This is Greenpeace bringing a claim at the time that Kinder Morgan was actually going public. And I shouldn't say bringing a claim, because what they did was they complained to the securities regulators that are reviewing the prospectus of Kinder Morgan during the IPO process. So they write to the ASC and say, we don't believe that the prospectus contains full, true, and plain disclosure of all material facts related to the company, particularly as it relates to climate-related issues and climate-related risks. The commission takes into consideration what the complainant says, eventually, under the way the prospectus approval process goes, there's no obligation on the Alberta Securities Commission to make any of its analysis public. Presumably, it would have had a discussion with Kinder Morgan as part of the comment process on whether there was any validity to this. Alberta Securities Commission satisfies itself and then eventually receipts the prospectus, and then the IPO is closed. So after Kinder Morgan goes public, Greenpeace attempts again in 2018 with another complaint to the SE, now complaining that that Kinder Morgan's ongoing disclosure documents still don't adequately address climate risk disclosures. Again, presumably there would have been some sort of discussion between the Commission and Kinder Morgan, but essentially none of that is disclosed, and the SE did not take any action in that case. Next slide. I'll touch on this last example, and then I'll let Tony chime in. So this is a case. Recall earlier I mentioned one of the things that the SEC had done is had this enforcement task force. So this is one of the things that the enforcement task force had done. It brought a civil action against Vale, a Brazilian corporation, that Vale had violated, again, Section 10B of the Exchange Act. So this is the anti-fraud provisions of the Exchange Act. And the facts of this case involve, which are actually quite tragic. In 2019, Vale has these dams, these tailings dams. In 2019, one of these bursts, and the toxic sludge in the dam flows out, tragically kills 270 people, flows into a river, and essentially kills the river. So the SEC looks at what happened, goes back, starts to look at all of the disclosures that Vale had made, and starts to find that Vale had made claims, which it couldn't understand how they could have made them, if these dams were actually at risk of failure. So if you go to the next slide, here's a few of the things that the SEC points out. So it looks at some disclosure from a 2016 investor presentation where Vale had claimed that its dams had been audited to address the potential for liquefaction using a rigorous process. It also discloses things like the audits were done with the presence of international auditors. So it actually goes through and starts picking apart some of the disclosure to say, if Vale had done all this, and if all this were true, then how could it be that this dam had burst? And as it turns out, the SEC is actually making a claim that the dams may not have been as safe as claimed, and that Vale may have actually had some of this information on some of the unreliable data that came up during these audits. So again, it's a case of the disclosure went out, but did Vale actually have the information that could have led it to conclude that the disclosure may not have been accurate at the time that it was made? I think there's one more example which you can read in the slide set that you'll have, but I think I'm going to pause there and let Tony chime in on the competition law aspects of this.
That's great. Thanks very much, Gord, and good afternoon, everyone. As you know, more and more companies are taking positive action on climate change, and they're seeking to communicate those strategies to the public. And this often puts corporate leaders in this double bind. You say too little, and you're often in this bind of being perceived as not saying enough. And then if you say too much, you're in the world that Gord and I have been talking about with respect to greenwashing, or sort of so-called climate washing. And so here is where I think I can add some perspective as to what one regulatory agency, namely the Canadian Competition Bureau, has really been focusing on. So what I hope to bring to your attention, if you just move on to the next slide, Cassie, is to really focus on three things. One being governance and greenwashing by way of overview, with a particular focus on the misrepresentation aspect under the Canadian Competition Act, but even more globally under consumer protection statutes around the world. I then want to turn our attention to Canada and really look at the analytical framework by which Canada's Competition Bureau and related consumer protection litigation focused on misrepresentation have been focused on. And then lastly, leave you with some best practices when making environmental claims to keep in mind. And much of this arises out of the advice we've been giving to clients but also some of the advice that arises from regulators themselves. So if you move on to the next slide, what I would say here, on to the next one, is that false and misleading and unsubstantiated environmental claims are becoming much more prevalent than I think we have seen in the past. And what we're seeing here is this renewed focus on whether or not ESG related claims can be either be substantiated or whether they're considered false or misleading to the general public, looking at it from the perspective of a credulous consumer. If you move on to the next slide, you'll see here that there's a lot of scrutiny being exercised by the International Consumer Protection Enforcement Network, and you're seeing a lot of activity in Europe, for example. Just a small example, the European Commission did a sort of this broad sweep of websites with respect to anything related to green related representations. And they found that 42% of the websites that they had reviewed were either, in their view, exaggerated, false, or deceptive, and could qualify for some sort of remedy. And they were very public about that as sort of a message to say, look, we really need to be sending a message out there as a form of general deterrence to discourage this kind of activity from taking place. If you move on to the next slide, in Canada, this isn't unique. I would just say there's been an evolution of it. So I would say the first green related or greenwashing related case was the very well known Volkswagen and Audi case, which arose in 2015 and 16 with respect to alleged defeat devices installed in automobiles to demonstrate that the car was so-called green or had green diesel in it when it didn't in fact do so, which led to a number of fines and litigation globally. More recently, and we're going to talk a bit more about this, there was the case of the Keurig Canada, which got into the crosshairs of the Competition Bureau with respect to certain claims about the recyclability of their coffee pods. And as we get into the case, there's a lot of sympathy for Keurig because their coffee pods are in fact 100% recyclable. But what happened there is that it had to do with whether certain municipalities in Canada were in fact doing so, and then whether or not how that then reflected on the misrepresentation at issue. Moving on to the next slide, and one further from there. Let me just sort of take you through what the analytical framework looks like. So first I would say is that the Competition Act in Canada is Canada's main legislation that govern false and misleading representations to the public. It's not the only one, but it's become the primary consumer protection related statute that deals with such misleading representations. And as a result of that, the main public enforcer of that is Canada's Competition Bureau, which is not a regulator per se, but a law enforcement agency. So what they're there to do is sort of look for and respond to complaints arising from false and misleading representations to the public, which can oftentimes relate to greenwashing related complaints. The Bureau actively investigates these things, and what they're looking for as a general matter is whether or not the representations are either false, true or not true, misleading, meaning they could technically be true, but convey a misleading general impression, or perhaps there's a performance-related environmental claim that's just not supported by adequate and proper testing. But importantly, in the context of civil matters, the Bureau acts as both the investigator and the prosecutor. They're not the judge that makes the final decision, but they do have that dual role. And so with that dual role, there's a lot of power afforded to them. Moving on to the next slide. What I would say here is that Canada, and I'll say this briefly, the Competition Act in particular has sort of a dual track perspective. There's actually civil and criminal provisions dealing with false and misleading representations to the public. I would say the Competition Bureau will, and they've stated this, err on the side of the civil, absent something where there is a reckless or an intent to deceive. And I would say in much of the litigation and investigations arising from this, the Bureau's erred on the side of civil. Moving on to the next slide. Why you may be wondering, why is this even in the Competition Act? For any antitrust buffs out there, you may be thinking this has nothing to do with antitrust, and I would agree with you. But the issue is in Canada, consumer protections built in with our Competition Act. And the reason being is that there's a prolific use of marketing and advertising in the Canadian economy, and there's a perception of an information gap between consumers and advertisers. And as a result of that, that is seen to not only impact consumers downstream, but also impact competition between horizontal competitors if someone is permitted to make false and misleading representations. So that's why it's included in the Act. Moving on to the next slide. Here, just as a snapshot, I'm just wanting to show to you that there are a number of false and misleading representation provisions contained in the Competition Act. The primary ones we're concerned about, I would say, are the misleading representations to the public, electronic messages, and sort of performance-related claims. But just keep in mind, there's a lot out there that can be used depending on the context and the representation at issue. Moving on to the next slide. Okay, so going through the analytical framework, what advertisers seem to be responsible for is not making representations that are either false, misleading, in a material respect. So false really means, is it true or is it not true? Misleading means it can be true or not true, but it conveys a misleading general impression to the credulous consumer, someone who's unsophisticated. So you've been to I'm sure to a mall before, you see a 50% off sign on the door, you walk in and 3 items in the back rack are 50% off and everything is regular price. So the sign was technically true, but it conveys a misleading general impression. So that's what regulators are really looking at and saying, okay, what you may be saying is true, but in an environmental context, is it really something that is 100% recyclable? Are your environmental representations more about buying and selling credits, or is it really something that you are achieving a certain target or not? These are the kinds of nuances that now we're starting to see, all sort of under the premise of just because it may be technically true doesn't mean that the representation being conveyed to the credulous consumer is true and accurate. And materiality is this notion of, is it germane to the purchaser's decision to purchase the product or not? 20 years ago, if you were to make a green-related representation, there would be a true argument to be made that it isn't really material to a decision of a consumer to buy the product or not. I would say that's changing quite a bit, and we're starting to see a customer base and a consumer base that's much more concerned about ESG-related issues, and will in fact buy a product or service in large part as a result of that. And we're starting to see that materiality is being triggered in many of these matters. Moving on to the next slide. I've covered a lot of this. I just wanted to make sure you had the analytical framework in mind. And in particular, when the Bureau is thinking about this, they're going through that 1 or 2 step analysis that's contained on the slide. So just when you're thinking about a representation, think about it this way, whether the misrepresentation is either false or misleading, and if so, whether or not the false and misleading representation is material in a sense that it's germane to the purchaser's decision, the product or service or not. And you'll see there are more of a description of that slide for your reference. Moving on to the next slide. Performance claims also is a different kind of regime where if you make a representation to the public that your product or service can do something or is better than competitors, there's a regime whereby you may be asked to demonstrate that you have adequate and proper testing to substantiate it. So moving on to the next slide. The trouble here often for companies is that it's a reverse onus. So if you make a representation with respect to the efficacy of a product or something about its performance, there's an assumption that you have adequate and proper testing to substantiate that. And the Bureau actually has the power to compel you to produce that in connection with their provisions. And that's a big reason why you want, when you're making ESG related claims, to be thinking about what substantiation you have in the event the Bureau tries to rely on a provision like this. Moving on to the next slide. So I just want to briefly touch on Keurig. And as I noted, this was a case involving the recyclability of Keurig coffee pods. Again, lots of sympathy for Keurig here because the pods are 100% recyclable. The trouble became here is that there were certain jurisdictions in Canada and in municipalities in particular that were not recycling them 100%. And so the critique of Keurig from the Bureau was that you can't really make general statements about the recyclability of those coffee pods if there are major jurisdictions in Canada that are just not doing that. for you. And so you have to have sort of a qualification of that representation. Moving on to the next slide. And as a result of this, the Bureau, sort of used this case as a basis, I would say, to as a general deterrence mechanism for the community as a whole, to sort of see what they may mean from general impression misrepresentations. So even though Keurig's statement was true, in the Bureau's view is misleading because of the lack of municipalities, a third party that the Keurig doesn't control doing so. So that's the length at which the Bureau went for this. Moving on to the next slide. Here you have H&M sort of making alleged representations. This is a Netherlands-based case, but it's important to point out that like the critique here was that companies were using terms like eco-design and conscious, and you start to see this kind of advertising. I bet you've all read advertising like this in the context of lots of products and services, and now you're starting to see it in clothing. And vague references to concepts like that are now being critiqued by regulators quite extensively. And so it's something you really want to keep in mind and make sure it's verifiable. Moving on to the next slide. What I would say here is that the Competition Bureau has been receiving a significant amount of complaints regarding greenwashing and sustainability. We all know this. I know this for sure, but I know a lot of people out there know this because the complainants are not being shy about it. Normally, these complaints are done confidentially, but you're seeing a lot of environmental groups now going out there publicizing the fact that they are making complaints to the Competition Bureau, in part to pressure the Competition Bureau to take action against companies for all sorts of representations that they say are false and misleading with respect to greenwashing related issues. So again, the Bureau, I would say, has become the hottest regulator, if you can say that, in Canada, sort of dealing with these kinds of matters, not by choice of the Competition Bureau per se, but because complaints are being brought to their attention by third parties. Moving on to the next slide. So in a nutshell, what can I share with you in the last minute or so to help deal with this? And we move on to the slide to follow. I would say that the Bureau does have a greenwashing bulletin. It had a more detailed bulletin a number of years ago that was actually created in 2008. And that bulletin used to say, don't make sustainability related claims because it's such an unknown concept. Lots of changes 2008, and you can see that bulletin's now been archived in place of this. I'm told the Bureau may be working on a revision of that's a bit more detailed than what we have now. But what we have now is essentially what's contained on this slide. So you don't want to make misleading statements to the public, but what you really want to be focused on is if you're going to make green related claims, make them specific. Try not to be sort of using vague concepts that can be misunderstood by sort of an incredulous or a consumer who's not seen as sophisticated. Make sure that your claims are substantiated and verifiable in some way. It doesn't mean that you need to necessarily hire a third party to do it for you. You can do it yourself. It's really a case-by-case assessment, but you do want something out there that sort of passes a smell test and it can be seen as sort of good evidence that the representation you're making is substantiated and verifiable. And of course, don't exaggerate your claims. And you all know that. But the other thing is that you want to be careful not to imply that your product or service is endorsed by a third-party organization if it isn't. And we're actually seeing a bit of an increase in that kind of complaint being raised. Moving on to the next slide, and I think this will be my final slide before we move forward, is that the industry as a whole, I would say, and regulators as a whole are really trying to expand upon what kind of claims should and shouldn't be made. I would submit that more guidance is necessary as this becomes an emerging issue, particularly when we start talking about net zero issues or things that are really down the road. But we are starting to see more guidance being provided. And a lot of the points that are on this slide that I've already talked about, I would say are good best practices to move forward on. And I think that's it for me.
Great. Thank you so much, Tony, and all of our presenters. And Tony, I can't wait for our joint pitch to Netflix for Canada's Hottest Regulator, the new Netflix series. I think that's going to be excellent. For the next part of the presentation, what we thought, because there's so much cross-cutting material, that we would all have a few questions that I would ask everyone to chime in on. And the first topic that I wanted to touch on, Gord, you had mentioned during your presentation, you made sort of a reference to one of the proceedings that you talked about being a class action. So what I wanted to do, just so everyone understands how class actions and the greenwashing and climate washing interact, is Kim, if I could ask you to just sort of tee us up with a 50,000 foot class action 101 framing. And then Tony and Gord would love to get your views on how the class action framing of a proceeding is relevant in the areas of law that you practice in. I would mention before we kick off, Kim, that this little segment is serving both as a warm-up for our panel members to answer all of your questions, and also a further opportunity for you to pose some questions. So we've had some good questions come in. We'll be coming back to them. But I would just encourage people to, if you have a question and haven't yet posted it in the Q&A box at the upper right of your screen, please do so while we're going through this panel section. So Kim, over to you.
Thanks, Kai. So generally, what a class action is a procedural mechanism by which a group of people who are similarly situated bring an action on a common basis, on the basis that they have claims in common. So it's an alternative to each person suing individually. And as Kai mentioned, Gordon and Tony will talk about the securities and competition law intersections of that. I did want to note that historically we've seen sort of environmental class actions grounded in nuisance claims when there are environmental spills and things like that. So it's not only sort of competition or securities class actions that we see, although those have been the ones that are most prevalent in this space. But it will be interesting to see going forward if we have sort of novel tort type arguments like the Peruvian farmer who's saying, you're responsible for my loss and having claims grounded in negligence. But basically the way a class action works is it proceeds in two stages. So the first stage is where the courts determine whether this should in fact proceed as a class. So there's a test that the proposed class has to meet in order to say that this should proceed by way of class action. There's significant differences in that procedure in Quebec versus the rest of the common law provinces. Both require a process by which something in the common law province, it's called certified. I think in Quebec it's authorized, but some process by which the court says, yes, you can proceed as a class. The procedure in Quebec is less onerous. It has a 4-part test, not a 5-part test. It's not just a matter of numbers, but that's all to say it's a less onerous test. And so it's a more sort of plaintiff-friendly jurisdiction. So we've seen some sort of climate-related class actions being initiated in Quebec. So once the class is certified or authorized and the court has said, yes, you can proceed as a class, the second step is then what you expect to see in litigation, where you go on to the trial. And in the case of a class action, it's a common issues trial. So when the class is certified or authorized, the court says, here are the common issues. These are the questions that need to be determined in common. And then that's what's determined at the second step in the common issues trial.
Great, thanks a lot. Gord, did you want to chime in on the securities impact?
Just a couple things on the security side. And I'll go back to one of the slides where I had the section 138 of the Securities Act, which framed what's required to bring a claim under securities law. And the key words there are, if there's a misrepresentation, and somebody bought or sold securities between the time the document is released and when it was corrected, they can bring a claim without regard to whether or not they relied on that actual statement. They don't have to show that they relied on it. It's not like a general civil claim where you might have to show damages to yourself or how you suffered injury from a tort claim. Just the mere fact that somebody bought or sold securities between the time of the misrep and the time of correction is all that's required. So it's a bit easier under securities law to bring these claims, which is why you start to see lots of securities law related class actions. And normally what plaintiffs' counsel are doing, they're really looking for companies where they see a steep stock price drop. And they say, well, why did the price drop so steeply? And they look to see if there was some sort of announcement that preceded that stock price drop. Then they read the contents of that announcement. Well, what did it say? Well, if they said X on this date, was there a period of time before that they should have said something else? And then they go back to the disclosure record and find whether or not there was some statement made earlier that could be a misrepresentation. And that's how these plaintiffs' class actions counsel can construct a class action under securities laws.
Great. Tony.
Oh, thanks very much, Kai. What I would say is that going back to Kim's point, right, it can be a challenge to find what the right cause of action is to ground an environmental claim. As Kim pointed out, many of them in the past have been based on nuisance and related issues like that. But you really have to find the right hook if you're a plaintiff for this. And what I'm starting to see, in addition to Gord's point, is a greater hook on the misrepresentation related representation, and the statutes like the Competition Act and others being relied upon to form the basis of a claim alleging greenwashing. So, for example, to the extent there's a Competition Bureau enforcement arising out of a matter, whether it's resolved by way of a consent agreement or this contested litigation before a competition tribunal, that will oftentimes be a leveraging point for a plaintiff to then bring a class action, relying upon the work that's been done and the findings that have been made there. Because that can be quite advantageous for a plaintiff to rely upon, particularly if there have been findings made that the plaintiff doesn't need to reprove in the context of a class action. And there are such provisions in the Competition Act that provide for this. But what's different and what the challenge is for plaintiffs is that those kinds of actions are not premised on whether you're not doing enough on an environmental basis. It's premised on, are you making false and misleading representations to the public about what you're doing? So it almost doesn't care about what you're doing. It's more about what are you saying to the public about what you're doing. And if that's the analytical framework, then the good news is that there's a lot of control that a company has over ensuring that it doesn't make a false and misleading representation to the public, rather than a more vague critique that you're just not doing enough for climate protection in Canada, which, it can be a much more difficult thing to defend in some respects, if it's especially if it's in the context of a publicity statement arising from that.
Okay, great. Thanks a lot, Tony. Moving on to my sort of second cross-cutting question for the panel. I know from my own practice in the area of greenwashing and climate disclosure and whatnot, that this is an area it's very new, it's rapidly evolving, and part of what makes it difficult to give advice in this area is that we're always having to look ahead. I think, Tony, you mentioned there's a change in what to expect consumers and what will matter to consumers. So maybe something that someone might have said 5 years ago as what's material might be different now. So in that spirit, and knowing that senior corporate leaders, can't look in the rearview mirror and they have to sort of look where the trend lines are heading, I want to ask each of you, from where you're sitting and what you're seeing with your clients, what are one or two maybe emerging risks, or even risks that are sort of over the horizon and aren't being spoken about, but you can foresee being significant issues in these areas of greenwashing and potential climate litigation in Canada? So this time I'm going to start with you, Gord, and then we'll have Tony chime in and ask Kim to close us out.
Sure. Thanks, Guy. So as Tony said earlier at the outset, a lot of this is about saying enough. Like, you should say what you need to say, and what you say has to be accurate. And when it comes to public disclosure for public companies of, let's say, financial information, most companies have a really good process by which they generate financial information, they review financial information, it filters up the organization, and it's disclosed. And a lot of that started, let's say, after Enron, when Enron was a case where a lot of things that were happening on the financial side didn't get properly disclosed. And since that time, we've had internal controls over financial reporting, internal disclosure controls. And so things that get put into securities law documents get vetted properly, and there's a process. As companies, either voluntarily or through upcoming requirements, start to disclose more things around climate-related issues. For example, if they start disclosing greenhouse gas emissions, as an example, do companies have a process where they do the same kinds of things that they would have done with financial information? Do they generate that data properly? Do they vet the data properly? Is it getting up the organization in the right way? And is somebody then deciding, yes, this is the right data that gets disclosed? Because if that process isn't happening, then there's a question of whether that data and what's disclosed, whether there's integrity to it, and then the risk of that data being wrong, getting out, and then the risk of getting a claim because the data was wrong increases. So I think people are starting to talk about this, and this is going to be a greater focus by companies on how do we make sure that climate-related data that we might disclose is, has the integrity that we're sure that our financial data has.
So almost a life cycle approach on the data that's being disclosed. Tony, what do you think?
Thanks, Kai. I think an emerging issue is drawing the distinction between what a false, misleading representation states and what may be omitted or not disclosed, or this notion of multifaceted businesses that have lots of different kinds of business lines or products, and perhaps the certain environmental claims relate to some portions of the business, but not all portions of the business. And ultimately, what kind of representation is being made to the public? Starting with the first issue, often the focus is whether that representation, namely the phrase, the paragraph, whatever the case may be, is false or misleading. And it's not traditionally been focused on what are you leaving out. But when you read the complaints being made public by environmental groups, they're saying, look, I see that you have certain commitments you want to make that are environmental in nature, but what you're omitting is that you're doing X, Y, or Z, which completely undermines that. And how is that to be treated in an analytical framework of whether something is a false or misleading representation to the public? I think time will tell, but that is an emerging issue with respect to how regulators propose to deal with that issue. And then again, like if you're a multifaceted business that offers lots of product lines and you're sort of making a claim about certain activity you're engaging in, do you need to carve certain things out? Like, do you need a disclaimer for whatever you're saying about the environment or not? Or is it that such scrutiny really isn't necessary because the consumer will understand what you're saying or not saying? So I think those are two emerging issues right now that are arising from, such greenwashing related claims.
Thanks, Tony. That makes a lot of sense. Kim.
So I want to touch briefly on carbon offsets. I think we're going to see increased scrutiny about the quality of those offsets. Lots of companies are now making net zero commitments and saying they're carbon neutral and relying at least in part on carbon offsets in order to make those claims. So just to make sure everyone knows what we're talking about, companies will buy offsets that will allow them to compensate for the emissions that they can't reduce in their own operation. So they'll invest in a project that somewhere else that is, reducing the carbon in the atmosphere. But there's huge, I've learned from Kai, who's this real expert in this space, that there's huge variation in terms of the kinds of offsets, the qualities of those offsets. Some of you may have seen the John Oliver expose, I'll call it, even though there's lots of criticism about the accuracy of it, but expose on the use of offsets. And so I think as companies are making these net zero commitments, you're going to have people asking more questions about how it is that they're making those claims, what kinds of offsets, how many offsets are they using to be able to make those claims. Right now, that market, the voluntary market, is largely unregulated. So there's certainly bodies that are creating sort of best practices, standards, guidelines, and things like that. And as that all coalesces around sort of more of a consensus about what is a high quality offset, the more potential there is for somebody to say, hold on a second, you said you were carbon neutral because you had planted trees in the jurisdiction where there were already trees or something like that. So I think there may well be a lot more scrutiny around the use of offsets in order to be able to make certain claims that may be a new hook for plaintiffs to make greenwashing allegations.
Great, thanks. That's yes, I as you mentioned, I have a practice in climate offset, carbon offset development, and also transactions, and it is an area that is increasingly an issue for both developers and people transacting in the market. So very good to bring that up. The third area we wanted to talk about, and I'm just going to read out one of the questions we received. Reminder. If you have a question that you haven't asked, please use the Q&A box at the top right of your screen. But I'll just read the question because it really is a good lead into our next cross-cutting topic. And so the question was, climate change efforts will need more metals to be mined for battery electric vehicles and other purposes. Won't the fear of climate litigation and greenwashing risks serve as another impediment towards growth of mining, smelting, refining in Canada compared to other countries? And I think that's a really good point, and it was the starting point for my third cross-cutting question. Because when I talk to clients in the mining sector about climate disclosure and ESG more generally, often the answer I get is, yeah, we're doing all of this stuff and we're setting these goals and we're setting targets, but we're not announcing them publicly. We're not talking about them publicly because then we might be at risk of greenwashing allegation or concerns about disclosure. And that's the opposite. That mismatch is the opposite of what you would think if you just went on the basis of newspaper headlines. You would think the mismatch is all about people saying too much and not backing up their behavior. This is getting to be a broader trend. People have called it green hushing as opposed to greenwashing. And I just wanted to sort of ask the panel to think about being in the shoes of a company that is concerned about what can they do. What can they disclose? Like, what are one or two best practices, really practical tips that you'd recommend to think about disclosures to make people feel, well, calibrate the risk of making a disclosure, mitigate the risk, and maybe build some comfort around disclosure? So let's start with Tony, go to Tim, and end with Gord.
Thanks, Kai. Well, what I would say first is, it's unfortunate if there is a green hushing trend, because I think that for the broader objective of ESG, companies if they're doing the right thing, should be telling the world they're doing the right thing to sort of encourage a movement that's important in society. And so I think that would be an unfortunate consequence if the laws that I deal with and others deal with are getting in the way of that good corporate conduct and disclosure. What I would say is that I think risks like this can be managed. I think we're in the stage right now where I think a lot of ESG related commitments are just being made thoughtfully and laudably without, a thought as to what these different analytical worlds may say about it. And if, as a best practice, if a lens of, before we put a statement out there or commit to doing a certain thing, let's think about it from the perspective of, could this be considered false or misleading? If there's that lens that is thought about early in the process, many of these regulatory risks, I would suggest, and litigation risks as well, can be mitigated significantly. There's no guarantee you won't be sued, of course, but I think, in working through with a lot of clients on issues like this, there's a lot that can be done early to prevent, the risk that a regulator would be concerned and litigants would see fit to sue. And the last point I'll make is that with respect to Canada and the question that was asked vis-a-vis other jurisdictions, you're seeing the scrutiny around the world. Like, not every country may be as up to speed as perhaps the European Union would be, or the United States or Canada, but we are seeing, I am on an international circuit with lots of contemporaries like me around the world, and we're all talking about the same issues. And so it's going to get growingly more difficult to avoid jurisdictions that perhaps are not thinking about these issues. I would suggest to you that many countries are considering these issues now and will continue, and that list will grow over time.
Great, thanks a lot. Now I've forgotten who's next. Kim, next is Kim. Kim, we're over to you.
Taking a step back, I think, part of the green hushing concern is a lack of, part of it is just the evolution and the pace of change in this space, where it's hard to catch up with what's happening yesterday, let alone knowing what you need to do tomorrow. But I think building in expertise on the board and, improving the governance structure to make sure that these kinds of things are being, part of the strategic planning, that you have adequate resources, that you have access to consultants and external advice when necessary. It's not the kind of thing that we can do on the side of our desk anymore. Like, it really is a growing area of expertise and of increasing importance and increasing risk. So I think, the green hushing type considerations will be mitigated if companies, hire a chief sustainability officer, have them report to the board, make sure they have consultants, and that the board themselves are sort of educated, because it's hard to know what you don't know. And I think the fear is that, some statement will go out and you had no idea it was misleading because you're not well versed in this space. So I think there's lots of training opportunities available, just making sure that the board and management are well educated, have access to resources that they need and the expertise that they need, so that there's confidence in the decisions that are being made by the company.
Kind of not a lot to add. I mean, I agree with everything that Tony and Kim said. The disclosure regimes should not be. There are safe harbors, and the key really is for companies to be satisfied with what they're disclosing. And most companies are pretty good at vetting it. So it would be. I agree. It would be unfortunate if green hushing really meant that companies aren't thinking about disclosing things because they're worried about litigation risks, but there are ways to mitigate it, as Tony and Kim have said. And one of the things that one discussion we've had with clients is when they think about climate-related, environmental-related issues and the risks and disclosure, where does the responsibility for all of that lay in a corporation? Obviously, you don't want to leave that with your marketing department, because that probably is the one thing that people are worried about. But between your finance department, your audit committee versus the legal group versus an internal environmental compliance team, it's useful to think about who is best placed to look at these types of disclosure, because really what you're trying to do is make sure that you have an adequate system in place to vet the disclosure properly. And I think if you go through that vetting process, you really do limit the risk of certainly these securities related claims. It's the disclosure that isn't properly vetted or is generated and gets out there without somebody thinking about it that really causes these risks.
Okay, great. Thank you very much. We have a few minutes for questions, and quite a few have been coming in, so thank you very much for that. We've had a couple of questions coming in around directors and officers liability and directors and officers insurance. Gord, I wonder if you're able to speak to whether it's things you're seeing in the market or just how to think about or risks around D&O liability and liability insurance.
Sure. There's a couple. You're right. There were a couple of different questions. One just around our costs increasing. I think the answer is yes, they are increasing. They have been for a few years now. it is important to read D&O insurance. It's important to figure out what the exclusions are. Generally, for public companies, you'll have D&O insurance that covers securities-related claims. Again, generally, it should cover ESG-related claims. The one thing that will be interesting to monitor over time is whether D&O policies start to change with respect to ESG risks. And I keep coming back to this. I go back to the process for vetting disclosure. The reason D&O insurance covers all kinds of claims under securities litigation, including claims because your financial statements are wrong, because insurance companies know that you have a process to vet financial information. The question is, when it comes to ESG-related claims in the future, will insurance companies also then start to say, well, wait a minute, what kind of process are companies following to make sure they mitigate ESG-related claims? What kind of process are they following to make sure that ESG-related disclosures are vetted? So we could see an evolution where insurance companies start to want to see more around processes that companies follow.
Great. Thanks a lot, Gord. Tony, we had a question come in around a lot of your presentation, and I think it's just because this is where it comes up most often, described a lot of the tests and the thought process from the Competition Bureau as if it was a business to consumer issue only. But then when you were talking about some of the broader issues, like it almost sounded like it was a corporate level, representations around corporations or representations that could come up in a B2B transactional content, business to business transaction. Could you clarify or comment on that? Are we only limited to consumer things, or are the issues that you raised broader than that?
Yeah, it's not just limited to consumers. The legal test is to the public. Now, generally, that's been viewed as a group of people, and generally speaking, much of the enforcement's been focused on sort of the public as a whole. But representations to a small subset of people, even if it's in a business B2B sort of context, would technically be captured. The question becomes, is there enough enforcement discretion that the Bureau wishes to exercise to pursue something like that? And would someone see fit to sue on such a basis? But technically speaking, it would be captured.
Okay, great. Thanks a lot. Kim, I wanted to direct a question to you, but we're going to start with you and then others can chime in. There was a question that someone asked actually before the session started about jurisdictional variation. So obviously when you gave us the map of different jurisdictions around the world, and there was a follow-up question about why are there so few cases in Scandinavia, but I want to focus inside Canada. If you're thinking province to province or federal versus provincial, what would you say in answer to that question about whether there's jurisdictional variation in risk on greenwashing claims or concerns around climate litigation? Start with you, and then Gord, maybe you could comment, and then Tony.
I think just in response to that international variation question, I think part of it is sort of the culture of litigation. Like, it will surprise no one that we see a lot of these kinds of cases in the US because they have a generally sort of litigious culture there, and we're waiting to see what there were some significant greenwashing type cases that are making their way through the US courts, and there's been jurisdictional issues which have prevented anything from happening on the merits in those cases. So I think part of it is sort of a litigation culture issue. Some of it is also just whether there are laws and policies in place that provide the hook for these kinds of claims. Like, we know that the Milieu Défensive case that I haven't talked about because you've probably all heard about it 100 times already, was a huge case in the Netherlands, but that was based on sort of a particular legal hook that they had there that they don't have elsewhere. So I think part of that explains the variation in the types of claims and the frequency of cases, and also where there's a lot of sort of environmental group activity.
Okay, great. Thank you. That's a useful sort of list. Gord, Tony, we only have a few minutes. If you wanted to just give a quick 1 second thought, 2 second thought about jurisdictional variation in your areas.
Sure, I'll go first. Just on, I don't think there's a real jurisdictional difference between the provinces of Canada and the securities law hook. The ability to make claims under securities law is essentially the same. Probably not a significant difference between Canada and the US on the hook on how you might make a claim, maybe a little bit, but not significantly. I think where there is a difference goes to Kim's point about the US is just more litigious, first of all. And then you heard me talk about the SEC is a bit more activist in chasing down these claims. And it's probably not surprising that they made a claim against Valet. It wasn't a domestic company, it was a foreign company. So I think cross-listed issuers with an SEC, with a US listing, should obviously be cautious because it is more risky in the US for litigation.
Great, thanks. Tony?
Just quickly, I think that you will see less of a discrepancy over time. If your country happens to have a competition/consumer protection public enforcement regime, you will see that this will come up. I think the disparities largely arise from this being an emerging issue, but you're quickly starting to see many countries trying to keep up because they don't want to be seen to be left behind or ignoring something that is a global trend.
Thank you, Tony. Thank you, Gord. Thank you, Kim. And thanks to all of you for joining us today. That brings us to a close on our session. Before you sign off, I encourage all of you to click the survey button in below the video player to complete your session survey. We really do welcome your feedback and are always interested to hear what topics you would like us to present on in the future. The next session in the 2023 Fasken PDAC series will be on ESG, addressing diversity, inclusive sustainability for resource companies, taking place Monday, March 6th, beginning at 7:30 a.m. Eastern Time. For those in Toronto, we look forward to seeing you in person, or of course to join virtually. Thank you very much, everybody.